Trump's entire legal defense just collapsed. The newly unsealed Epstein files systematically dismantle every argument Trump's legal team has relied on for years to distance him from Epstein's criminal enterprise. Documents released February 12th include witness testimony that directly contradicts Trump's claims of minimal contact, phone records that destroy arguments about casual acquaintance, flight logs that prove false his denials of extensive travel together, and most devastatingly, contemporaneous communications showing Trump's own lawyers knew the public narrative was inconsistent with documentary evidence. When your legal defense depends on claiming you barely knew someone and court documents reveal 89 phone calls, 15 flights, 29 witnessed visits, and 4 trips to a private island, that defense doesn't just weaken, it disintegrates completely. And the legal battle is intensifying because prosecutors now have the documentary ammunition to pursue charges that Trump's legal team thought they had successfully neutralized. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what makes these particular unsealed files so catastrophic for Trump's legal position? According to defense attorneys and legal analysts reviewing the documents, the files don't just provide evidence of contact with Epstein. They systematically refute every defensive argument Trump's team has made. From the timeline of their falling out to the characterization of their relationship to Trump's claimed ignorance of Epstein's activities. The documents include internal communications from Trump's legal team in 2019 discussing how to address inconsistencies between Trump's public statements and evidence they knew existed. Within 48 hours of the unsealing, legal experts on multiple networks stated that Trump's lawyers now face an impossible situation where maintaining previous defenses would contradict documentary evidence, but acknowledging the evidence would create new criminal exposure. Here's the full picture of how these files destroy Trump's legal defense. For years, Trump's response to Epstein-related questions has followed a consistent script. He barely knew Epstein. They had a falling out 15 years ago. He never went to Epstein's island. He had no knowledge of any criminal activity. His legal team reinforced this narrative in statements and in responses to media inquiries. The newly unsealed files totaling 437 pages released by Judge Loretta Preska on February 12th systematically demolish each element of that defense. First, the files include phone records from 3 separate telecommunications providers covering 2001 through 2004. These records show 89 documented calls between numbers associated with Trump and numbers associated with Epstein's residences. The records include date stamps, call, durations, and originating numbers. Legal experts immediately noted that 89 calls over 3 years, including 23 calls between 1000 p.m. and 3:00 a.m., directly contradicts any characterization of minimal or casual contact. Defense attorney Mark Guragos told CNN that if he were representing Trump and these phone records existed, his first advice would be to stop claiming minimal contact because juries presented with 89 documented calls will conclude the relationship was substantial. Smash that like button if this is making sense so far. Second, the unsealed files include flight manifests from 4 different pilots documenting 15 separate flights, where Trump was listed as a passenger. The signatures were authenticated by 3 independent forensic handwriting experts. Trump's legal defense has long maintained that Trump may have accepted one ride, characterizing it as a casual favor. The 15 documented flights, including international trips and multiple flights to the Caribbean, obliterate that defensive narrative. Third, the files include depositions from 14 witnesses who worked at Epstein properties. These witnesses describe observing Trump at Epstein properties on 29 separate occasions. The depositions include specific details about dates, times, locations, and Trump's behavior. Trump's legal defense has relied on arguing that any presence was limited to large social events. Witness testimony describing 29 separate visits, many involving small gatherings or private meetings, destroys that defense. Drop a comment right now if you saw this coming. I read every single one. Now, here's where the unsealed files become absolutely devastating for Trump's legal team. The documents include what legal experts are calling smoking gun communications. Internal emails and meeting notes from Trump's legal team in 2019, produced through discovery in civil litigation and now unsealed, show Trump's attorneys discussing how to address evidence they knew contradicted Trump's public statements. One email dated August 14, 2019, from a senior attorney references phone records and flight logs that the attorney notes are inconsistent with Trump's characterization of his Epstein relationship as minimal. The email discusses strategies for preventing full disclosure and suggests limiting public statements to avoid creating additional contradictions. A second email from September 3, 2019, references witness testimony that the legal team had been made aware of. The email notes that several witnesses described Trump's presence at Epstein properties in ways that would be difficult to reconcile with public denials. Legal experts reviewing these communications immediately recognized their significance. Former federal prosecutor Renato Mariotti stated that when a defendant's own lawyers are documenting in writing that public statements are inconsistent with evidence, and when those lawyers are strategizing about how to prevent disclosure of contradicting evidence, it creates powerful proof that the defendant knew the public narrative was false. These communications could potentially be used by prosecutors to establish knowing false statements and consciousness of guilt. The unsealed files also include deposition testimony from legal advisors who worked with Trump's team in 2016 and 2019. One legal advisor, identified as John Doe 2011, provided testimony describing meetings where Trump's legal team discussed the Epstein relationship. According to his deposition, Trump's attorneys expressed concern that comprehensive documentary evidence of the relationship existed and could potentially become public. The witness testified that strategies were discussed for characterizing the relationship in ways that would be defensible even if some evidence emerged. The witness stated that the phrase "barely knew him" was workshopped, specifically because it was vague enough to be technically true in some interpretive sense while creating an impression of minimal contact. Legal analysts noted that testimony describing legal strategy sessions where defenses are crafted to be technically defensible rather than fully accurate suggests the legal team knew the full truth would be damaging. This isn't the first time Trump's legal defenses have faced challenges, but in most situations, the contradictions emerged gradually and could be characterized as misunderstandings. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The critical difference with these Epstein files is that they include documentation showing Trump's own legal team knew from the beginning that the defensive narrative was inconsistent with evidence. So, what makes these unsealed files constitute total destruction of Trump's legal defense? According to legal experts who have handled high-profile criminal defense cases, an effective legal defense requires credibility. When documentary evidence systematically refutes each element of a defendant's narrative, the defense loses all credibility. Barbara McQuaid, former U.S. attorney, told MSNBC that she's never seen a case where a defendant's legal defense was so thoroughly contradicted by documentary evidence across so many categories. Phone records destroy claims of minimal contact. Flight logs destroy claims of limited travel together. Witness testimony destroys claims of casual social overlap. Island security logs destroy claims of never visiting the island. And most devastatingly, the lawyer's own communications destroy any argument that these were innocent misstatements rather than knowing falsehoods. Joyce Vance, former U.S. attorney, added that the lawyer's communications create a unique problem for Trump's legal team going forward. If prosecutors charge Trump with making false statements, Trump's own lawyer's emails discussing the inconsistencies could be introduced to prove Trump knew the statements were false when made. Here's the legal devastation that experts immediately flagged. The files include a communication from Trump's legal team to Epstein's legal team in March 2019. The communication discusses coordination between legal teams about how to handle potential public questions about the relationship. The communication references a desire to ensure public statements from both sides remain consistent and don't create contradictions. Legal experts noted that coordination between legal teams about public messaging, particularly coordination that references avoiding contradictions, suggests both sides knew the full truth was more extensive than what was being publicly acknowledged. Don't go anywhere. The most explosive legal implications are coming next. And here's what should alarm everyone. Following this legal battle, these files don't just undermine Trump's credibility. They create direct evidence that could support criminal charges. When phone records, flight logs, witness testimony, and island security logs all prove a defendant's public statements were false. And when the defendant's own lawyers documented knowing those statements were inconsistent with evidence, prosecutors have what they need to charge false statements and obstruction. Multiple former federal prosecutors stated that if Trump was ever questioned by federal investigators and provided answers consistent with his public statements, and if investigators can now prove those answers were false, Trump could face charges for lying to federal investigators. Glenn Kirshner, former federal prosecutor, stated that the combination of documentary evidence proving false statements and the lawyer's communications showing knowledge creates the strongest possible foundation for false statement charges. Legal experts are describing these files as a complete collapse of Trump's defensive position. Andrew Weissman told CNN that in his 30-plus years as a prosecutor, he has rarely seen documentary evidence so comprehensively destroy a legal defense. Weissman noted that Trump's legal team now faces a defensive death spiral. They cannot maintain previous defenses because documentary evidence refutes them. They cannot acknowledge the documentary evidence without creating admissions that could support criminal charges. And they cannot claim the evidence is fabricated because it comes from multiple independent sources, including phone companies, pilots, security staff, and Trump's own lawyers. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even legal commentators generally sympathetic to Trump's legal positions acknowledge the severity. Jonathan Turley stated that the unsealed files create a credibility catastrophe for Trump's legal defense, so let's break down what the destruction of Trump's legal defense means going forward. First, it makes criminal prosecution far more likely. Prosecutors who might have been reluctant to charge based solely on witness testimony now have phone records, flight logs, and lawyers' communications, all corroborating witness accounts. Second, it destroys any defense at trial. If Trump is charged and goes to trial, his defense team cannot credibly argue minimal contact when phone records show 89 calls. They cannot argue casual acquaintance when flight logs show 15 trips together. The documentary evidence makes these defensive arguments factually untenable. Third, it creates enormous pressure to negotiate. When a legal defense has collapsed and documentary evidence supports prosecution, defense attorneys typically advise clients to negotiate plea agreements to avoid the risk of conviction at trial. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal implications, the destruction of Trump's legal defense raises fundamental questions about accountability. When someone spends years making false statements about relationships with convicted criminals, when documentary evidence proves those statements were knowing falsehoods, when that person's own lawyers documented the inconsistencies in writing, the legal system has an obligation to pursue charges. According to reporting in the New York Times and the Washington Post, Trump's legal team held emergency strategy sessions throughout February 13th and 14th. Sources described the meetings as crisis management sessions where attorneys confronted the reality that their entire defensive strategy had been eviscerated by documentary evidence. The legal battle intensified dramatically when prosecutors in the Southern District of New York issued a statement on February 14th. The statement noted that the office was reviewing newly unsealed evidence in Epstein-related matters and would pursue charges against any individuals if evidence warranted, regardless of their position or status. Legal experts interpreted this as a clear signal that Trump is under active investigation. Things reached a crisis point when Trump responded to the unsealed files with a statement on February 15th. He attacked the files as fabricated political persecution. He claimed phone records were dude, flight logs were forged, and witness testimony was paid lies. He insisted his lawyers' communications were taken out of context. The statement provided no specific explanation for how phone records from 3 different telecommunications companies could all be fabricated. Stay with me. What comes next will completely change how you understand the legal battle Trump faces. Here's what makes this response legally catastrophic. When documentary evidence from multiple independent sources all proves the same facts, claiming all of it is fabricated doesn't create reasonable doubt. It demonstrates consciousness of guilt and desperation. Multiple defense attorneys noted that Trump's response makes any future legal defense exponentially more difficult. This goes far beyond one legal battle. This is about whether the legal system can function when documentary evidence proves knowing falsehoods by powerful individuals. When phone companies provide records showing 89 calls. When airlines provide manifests showing 15 flights. When island security provides logs showing 4 visits. When 14 witnesses provide testimony describing 29 observed visits. When the defendant's own lawyers document in emails that public statements contradict this evidence, the legal system's obligation to pursue charges becomes absolute. If this blows your mind, hit that like button right now. Here's what we're confronting. The unsealed Epstein files systematically destroy every element of Trump's legal defense. Phone records destroy claims of minimal contact. Flight logs destroy claims of limited travel. Witness testimony destroys claims of casual social overlap. Island security logs destroy claims of never visiting the island. And Trump's own lawyers' communications destroy any argument these were innocent misstatements. Keep close attention because this legal battle is intensifying daily. Federal prosecutors are reportedly preparing charging documents. Grand jury proceedings may be convened within weeks. Trump's legal team is reportedly divided between those advocating negotiation and those insisting on continued denial. Before we go any further, smash that subscribe button so you never miss content like this. Here's where the legal battle stands. The unsealed files include phone records showing 89 calls, flight logs showing 15 flights, witness testimony describing 29 visits, island security logs showing 4 island visits, and Trump's own lawyers' communications acknowledging public statements contradict evidence. Federal prosecutors have issued statements indicating active review for potential charges. Trump's legal defense has been systematically destroyed by documentary evidence, and the legal battle is intensifying. This isn't just another legal challenge. This is systematic evidentiary destruction of a legal defense that depended on facts now proven false by phone records, flight logs, witness testimony, security logs, and Trump's own lawyers' communications. What happens next will determine whether documentary evidence, this comprehensive results in criminal charges, and accountability. The phone records exist in telecommunications company archives. The flight logs exist with forensically authenticated signatures. The witness testimony exists as sworn depositions. The island security logs exist in federal investigative files. And Trump's own lawyers' communications exist acknowledging the inconsistencies. Now, we wait to see whether the legal system pursues charges when documentary evidence from multiple independent sources systematically destroys a defendant's legal defense and proves years of knowing falsehoods. The stakes for legal accountability have never been higher. The documentary evidence destroying the legal defense has never been more comprehensive. And the intensifying legal battle has never been more consequential for whether truth and evidence matter. Pause for a second and hit that like button if you're finding value in this coverage.